Okay. Good morning, everybody, and welcome to the February 2023 webinar. I say that with this face because 2023 in February, it still feels like it's 2004, which is the first time I may or may not have gotten taken into custody. I bring that up because if y'all don't know, I've been posting a lot on Instagram and on TikTok, which I say with a smirk and a level of embarrassment. But I'm having a lot of fun doing them. And yesterday's video was actually about a time I may or may not have been taken into custody, I believe was the word that the police officer used. So I encourage you, if you're interested, follow me on Instagram and or TikTok if that's your world. But it's been a lot of fun on there. We have, I think, 8 videos with more than 2 million views on TikTok. And if you are really, really bored, try watching or try reading the comments because they're absolutely insane and maybe reason enough to do it. Paul Simon just congratulated me in the chat on being a super duper amazing, greatest lawyer. For those of you that are interested, the Rafis, I believe are going to happen in April. April's my goal. That way the hangover of super lawyers is over and we can really get down to the best awards that will be hopefully done annually, which are the Rafi Awards. I see some people in here that are in the running for some of these awards. So hopefully you're excited about that. Today is easy for me. Today is pretty easy for me. I woke up this morning. I didn't have I have nothing prepared. I haven't talked to Brendan or Colin about their cases specifically. When they first had them or leading up to them, at least in the case of Colin, we talked about it. But I don't know a lot, and I've purposely done this because I genuinely want to learn about their cases. I want to ask about what's happened, and I want y'all to do the same. So as we go through this, let me tell you, please put your questions in the question and answer prompt, and we'll make sure to answer them all. If you've tried 100 cases, which I see some people on here that have, that's awesome. If you want to make a comment and share what you know, that's great. Love that. If you're somebody who hasn't tried any cases and you have what you think is a stupid question, this is the place to ask stupid questions. That's why I'm here, to ask stupid questions for you. But if I miss something that you want to know, ask it. Ask it. There's absolutely no shame in here. And the only way you learn is by asking those stupid questions and getting used to, learning things you don't know. Bruce Berger on here, a lifetime of learning. He can tell you firsthand that, don't be embarrassed to ask something, no matter what. So let me introduce the 2 people that are coming on here for us. The first one is Brendan Flanagan, who apparently has 2 logins in my webinar right now. So we'll see him or somebody else. We see a good looking photo on the screen right now. Brendan does not have a sport jacket on. I'm surprised, but it looks like he was golfing this morning. Yes?
Yeah, no sport jacket. Not today, no blazer.
Well, I've known Brendan now, afraid to say, 14, 15, something like that, since 2014, 2015.
Somewhere around there, yep.
But Brendan tried a case recently that he's going to tell us about. He got a really good verdict relative to the case, and I think he's got some really good tips that he can talk to us about. Plus, he can always give us hairstyling tips, dressing. I mean, whatever you need, he can do. And let me get Colin in here. So Colin Barron is with the Haug Law Group. Funny enough, the case that Colin tried, and that we're going to talk about, was a case that was right before mine, right? You were the one before me?
Yep, that's correct.
So I was hoping he would settle his case or something would happen so I could go and I could try it. And James is correcting me. It's Haug Barron Law Group. Colin, excuse me. Sorry. I was in the past there. Version 1. Now your firm is in version 2. Pretty soon, James is going to be not saying that when it's Barron Haug Law Group, because you guys should be able to switch it back and forth is my thought. But thank you for coming, guys, and looking and dressing better than me. Brendan, you want to just start telling everybody a little bit about your case and the facts we need to know?
Yeah, sure. I want to start out by saying I'm a super lawyer. I'm a top 40 under 40, and I'm also one of America's top 100 personal injury.
But are you one of the best Black female lawyers in America? Because 2 years ago I was. Not a joke. I nominated. To be honest, I nominated myself just to see if it would happen, and it did.
I was nominated, but for that one, I couldn't afford the entry fee. And so maybe next year. No, but all joking aside, I do think it's funny how much you kind of hate on the awards, because it is. I mean, a lot of them are BS, but clients, I can't tell you how many times I've seen a client say, "Oh my gosh, my attorney's a top 40," or "My attorney's a super lawyer," something.
I'll throw something. I just want to throw something. No, with that said, I'm going to say this because it will go, it'll go on YouTube. It'll save me the LinkedIn comment I get every year. I do this twice a year, my rants, because I go like 5 months and I'm like, I'm not going to do it this year. I'm not going to say anything. And then more awards come like October. But every year I get the comment, you advertise your super lawyer awards on your profile. Yeah. And I think it's bullshit and it sucks. It's because all of us advertise that stuff. And some client, like you just described, says, well, I don't know. He's not a super lawyer. I don't know if I want to hire him. Look, I'm a hypocrite. I'm not taking that risk. But if we all just universally said the only awards we're going to advertise are the Rafis, I mean, everybody's a winner there. Everyone. All right. Sorry. Let's, I don't want to talk about that for an hour because I would, I literally would. By the way, if you're on this webinar, you don't know what we're talking about. For the last like 6 years, I complain about two things in my life on a regular basis. One is that Taqueria del Sol only has one register. If they would just get 2 registers, they can't even fill all the tables in there because the line is so long. I went yesterday and it was raining. I stood outside, just get a second register. Second thing are these awards, which admittedly, when I just started, I got these awards and I was like, holy shit, this is awesome. I paid for an ad in Super Lawyers. Fast forward like 3 years after that, they wouldn't run my ad because my ad was apparently offensive to them because I said this award means nothing and something like that. But now every year I just go on this rant about these fake pay for awards, which I think trick consumers because they don't know it's bullshit. And that's my 2 cents. If you got an award and it makes you happy, that's awesome too. I don't mean to bring you down, but anyway. All right, sorry. Let's get back to the topic here. Let's get back to the topic.
So this is, I'll start off by saying, this was a fun case to try. It was in Fulton County State Court. I tried it with another attorney in our office, Morgan Lindell, who's extremely smart and talented. And she helped a lot with this case. This was her first opening statement. But this is like the quintessential clear liability insurance company just won't offer anything reasonable. So we were forced to try the case. I liked it for us because we were basically forced. We tried to settle it many times. But the long short of it was the client had about $20,000 in medical bills. Progressive never offered more than $15,000, despite us saying, hey, we'll take 40, or we'll take, we were basically telling them, hey, because a lot of clients don't want to go to trial. A lot of clients would rather not wait and go and just deal with the uncertainty. They'd rather settle the case. We provided all those opportunities to Progressive. And from the day we filed a lawsuit until trial, they didn't even offer anything after trial. They just stuck with their 15, which to me was a sign of a disrespect. And it fired me up to just kind of, go and try this case and really stick it to them. Because I get like that's personal to me, right? I'm looking, the old saying, don't look to gift horse in the mouth. I'm coming to you and saying, hey, we'll take double the meds, and you're telling me to, F off. Well, then I'm going to run circles around you. And that's what we did on this case. This was
was it defended in-house? Is that who defended it?
It was in-house, and then she went to another firm. And I don't want to disparage her or anything, but I just think
please don't. This will be used. These webinars will be used against you. They're used against me every month.
She took a position throughout the whole case that was just completely it was just disrespect. I mean, going to mediation and hey, well, we've already given you our top of 15. We don't have a billing expert. We don't have a doctor. We're not going to put up any evidence in the case other than, hey, 15. So our theme throughout the case was, all the defense is doing this whole time, and the whole reason we're here, the reason you're here, is because they want to diminish and deny and not be reasonable. And I have a slide up in my closing that says, you're about to hear why we're here, why we've been here for 4 years, because they refuse to be fair and reasonable. And then when she gets up and the defense attorney gets up and says, give them 0, everyone on the jury's like, well, oh, what? Are you serious?
So wait, all right. So, all right, hold on. Do you have coffee this morning?
A little bit.
I can feel it. I can feel it. I like it though. I like it. So they go 15, and I'm jumping around. We'll go back. I just want to get a real quick lay of the land, and we'll go back and forth here. But they offer 15. What was her basis for offering 0 at trial?
They just basically said, the medical bills are unreasonable, and they had looked at her social media accounts. My client was she's a performer, and when I say performer, I mean she's got a radio show on iHeartRadio. She's on Spotify. Wow. Beautiful voice, beautiful, talented singer. But I would tell her, hey, they're going to look at your social media, so you might want to consider that. She would never put her social media on private. She's like, this is my brand. This is who I am. But of course, they tried to have a field day with that and say, look, she's out doing these performances, and she's, so they tried to say, well, she really wasn't hurt, and it really wasn't a bad crash. So, give her 0.
Damn.
One of the things that I think really, one of the things that was kind of shocking, but I think led to our success was in the defense counsel's opening statement. She got up and said, plaintiff and her attorney 2 days after the wreck walked together, and she made this symbol like they're holding hands, and they held hands and walked right into the chiropractor's office and signed up. So she tried to make, which is not true, and there's no evidence of that. She was basically saying there was a letter of protection that was signed, a lien that was signed by the attorney and the client to go get chiropractic treatment. Right. The client had testified that her friend had been to this chiropractor before and referred her there. But anyway, she made this ridiculous statement that was not supported by any fact, any evidence. The judge let it in. The judge let the jury.
Hey, unrelated question. Who was the judge in this case that you were before?
Yeah, the judge was Patsy Porter, but she had a sub-in, a magistrate court judge named Eric Morrow, and he is in Fulton County Magistrate Court. So he is the judge on the case.
That's interesting. Was this through Fulton County's got that? What is it, ORCA, which is the separate program that's trying cases? I have 2 specially set that I'm waiting on through that program. Was this through the normal state court feeder, or was it through the separate program?
I think it was through the state court feeder. They just kind of sprung it on us last minute, like, hey, your trial's getting called, and by the way, here's your judge. And we just didn't. I mean, we were just happy to get called in. So I wasn't complaining about who the judge was, but I thought it was interesting that there was no curative instruction on, hey, that's not true, and you can't just say that in opening statement. Because then I tried to bring it up in closing, like, hey, you just heard how ridiculous this was, that her attorney just walked together down to the chiropractor's office and signed up. So it was all this just foolishness. it was, we were. I think I would have looked at my
calendar and been like, I was doing something else that day. I didn't walk with anybody.
Exactly. Well, the case was referred by another attorney. That attorney wasn't there. The judge ended up letting in the fact that this letter of protection was signed by an attorney, despite the Stevens case, which clearly says, hey, you can talk about bias with judges or with liens, but guess what? That has to come in through the doctor. That can't come in through the client. That can't my client can't testify about what she thinks her doctor is biased. So the whole point of this was Progressive was the insurance company. They didn't present any evidence. They didn't have any experts. They didn't cross-examine anyone. So all these arguments that they're making are just coming out of thin air. And we're sitting there telling the judge and telling the jury, hey, focus on the evidence. The case is about evidence. It's all about evidence. They didn't have any evidence. So they're just
we've got something like that coming up, and I want to talk to you a little bit about a directed verdict or some things that to eliminate those kind of lawyer arguments. You just said about the bias of a letter of protection. Colin recently-ish, now it's been a year, was looking for someone to join a case of his because he had, I think, similar arguments that at least there was the defense was claiming. Colin, you can tell better than I can, but the defense was claiming similar things, right?
It's the case I'm going to talk about. Same case.
Okay. Oh, okay. Great.
Yeah.
All right. So yeah, I guess that's right. I had the case behind you, and I was technically an expert on the file. All right, why don't you tell everybody about the case and how the heck I am sort of involved, because it ties right into what Brendan was talking about.
Right. Without getting too far into the whole case, which I'm sure we'll talk about later, how Mike got involved was we had a case where the client treated on letter of protection, and 3 of the treating providers had already been deposed evidentiary depositions in this case. And we go to file our motions limine. We move to exclude any evidence of medical funding that she had. There was no evidence of bias because the doctors had already been deposed. For evidentiary purposes, we knew there was no testimony on the bias regarding the medical funding. The judge, it was Judge Colvin out in Gwinnett, who did a good job during trial, and I think she just made a bad ruling here. She was going to allow evidence of the medical funding in. Well, what I did was that I said, well, fine, Judge, you got to let me notice an expert witness to explain to the jury what medical funding is and how it works in personal injury cases. And the thought process the whole time, and this was not a novel idea, I've heard of people doing it before, was once they realized that we were just going to get to blow the doors off collateral source and pull back the whole curtain, they would withdraw their evidence, which is eventually what ended up happening on the run up to trial once we got on a calendar towards the top of a calendar. But I decided that there's no one to explain better how funding and personal injury works than a personal injury attorney. So I reached out to Mike and asked if he would do it, noticed him as an expert. He was deposed for purposes of discovery. There was a Daubert motion filed, which we obviously responded to. We defeated the Daubert motion. And so Mike was going to get to testify at my trial as a witness and then maybe turn around and try his own case, the next day. But once we defeated the Daubert, once defense counsel sort of realized how this was going to play out for them, they withdrew the evidence they were going to submit.
And I'll give everybody, one quick explanation about that deposition. When I did defense work, I did not understand how plaintiffs and how medical funding and things like that worked and why it was necessary, why it was truly, truly necessary. I do now. And I was the defense lawyer, I think, was also kind of clueless about how it works. And I walked in there, and really just said, here are the 3 reasons why people get medical funding. And everything I said, I think every question, every answer would have been disallowed under the collateral source rule. But the whole goal was, if you're going to try to bring in this little sliver that benefits you, then we, like Colin said, we got to bring up everything and open the doors. And I was talking about how people don't have insurance and how it's more expensive and how you have access to doctors. And then the only thing we didn't cover, amazingly, I didn't get asked at all about reductions. Wasn't asked at all about them. And that's what I was worried about, right? Because you have to explain that in a way that makes sense to people. So yeah, that's my 2 cents. So Colin, why don't you tell everybody real quick the facts of your case and then how it turned out?
So we had a admitted liability rear end collision with, I will put it gently, little to no property damage. I wrote down some pros and cons sitting here. I had a great client. She's a woman in her mid-50s. She was a CNA for a long time, kids, grandkids, really likable, really sweet, a decent enough witness, smart. And actually between this collision happened in 2015 and we just tried the case in January. So she had to wait her turn to go between, her treatment completing and this. She actually became a truck driver, really good client. And so admitted liability, rear end collision, testimony from my client that she was sitting at a light, saw the defendant coming, placed her arms on the steering wheel, braced for impact, some neck and back, minor stuff, nothing serious. The real whole case is about her shoulder. She starts a course of treatment, gets referred to an ortho, MRI, so on and so forth. And there is a recommendation for a right shoulder scope about 3 or 4 months after the collision. She ends up not getting the surgery for a handful of reasons. Some of it was related to the funding that was involved in the case. Some of it was related mostly to the fact that she had blood pressure issues and wasn't cleared for surgery immediately. Also of note, and was a big theme in our case, she suffers from rheumatoid arthritis and a condition called sarcoidosis. So the negative to the case, or one of the big negatives, was there really just wasn't any great pain and suffering testimony. She had to miss some work. She had to go through the surgery, but otherwise, and thankfully, the surgery worked. She healed up. Her life was disrupted, but nothing ruined, so on and so forth. So we really had to lean into the fact that, look, this is a tough lady who's dealt with some stuff on the health front, and she just keeps chugging to sort of offset the lack of pain and suffering testimony. She ends up getting the surgery after about a 6-month gap, sort of a year after basically the collision happens, and gets better. Like I said, does some PT, and she's good to go, essentially 100% healed. which is great for her. How it ends up going is, and there was a bunch, like I said, there's 3 of our doctors who were deposed via video. This was all, COVID, so all the docs were video depped. They hired Torrance Welsh, a biomechanical expert, to provide testimony that there wasn't, adequate force to cause the shoulder injury, the tear in her shoulder, so on and so forth. We tried the case, and prior to trial, I think the top offer was somewhere in the range of $20,000. We had $147,000 in medical bills. And there was an offer of settlement for $4,000. Okay. So Brendan, sort of your point earlier, this was a good one to try because there's no pressure on us. I mean, they never put any risk in our room. There was never any decision to be made. It was, all right, let's tee it up and see what happens. We've got nothing, literally nothing to lose. We try the case, and the jury awarded, and I've never seen this before, exactly the amount of specials and no pain and suffering. And we got some good jurors to talk to after, and I don't know how far you want me to go, Mike, but I could jump into what they said. And obviously that number represents, they weren't putting that they don't believe that she suffered at all. That was a compromised jury between folks in the jury room who wanted less, some wanting 0, some wanting more, and they just settled on the specials. But as the
was it to the penny? Was it to the penny?
The exact amount of medical bills.
Wow.
The verdict form had a number for special damages and a number for general damages, and they literally wrote the specials and a 0 in the pain and suffering. And sitting there listening to the foreperson read out the verdict, I hear the first number get read, and I'm going, let's go, we've got it. And then she just stops. And
logically that's not possible. Like, you can't, a jury, in logical reasoning, right? If this is an LSAT question, if the jury awards all the specials, must there be pain and suffering from the surgery that they clearly say was related? Yes.
I think there's a jury charge that says pain and suffering is inferred after injury.
So it was
what county were you in?
Gwinnett,
right? And
we had a pretty good panel, a pretty good jury. It was fair. It was fine. Nothing to be worried about. Judge Colvin was the judge.
That's right. Okay.
She, like I said, I thought she did a nice job during trial. She let us try the case because all the depositions were video. All the objections, the few that there were from the doctors had already been heard. So it was a unique trial, and then really there wasn't too much to be prepared for, because 4 of the witnesses were video, which was an issue for the jury when we talked to them. That put them to sleep, and I don't know there was a solution to that problem, just given why we had to take those depots via video during COVID and so on and so forth. But that was an issue with them. You
say during COVID. I mean, are you? I don't. In terms of treating doctors, at least I can think of 2 times that we've ever had a treating doctor come in. It cost us, I want to say $15,000 for the day.
Right.
And it was a local doctor. Have you been able to do that? Or because what the heck can we do about that?
No, I think you're right. I think same here. I'm with you. I think maybe one time outside of perhaps a chiro, who those are easier to get to come in if you've got a case that needs it. But the orthopedics are all going to be video. The witness that I would anticipate would have come live and we'll see how that would have went. Who knows? But would have been their expert, I think. And that was also the longest deposition, and it was also the last one played. So I don't know if that one was hanging in their head the most. It was also probably the most boring of the 3 or 4 depositions that were played via video. But it was an interesting result in the context of what had been previously offered. Obviously, it's a success from that standpoint. To not, the oddity of the result, and to not, get a bigger number was obviously a disappointment. So,
but at the same time, you're not in a bad position as a lawyer and a client, because you didn't have another option. I mean, you did. What did they ask for in their closing?
I don't think that she asked for a specific number. And she certainly did not ask for a 0 by saying 0, sort of left it open. I thought it was a reasonable way to walk that line, but not perhaps pissing a jury off by saying, give this lady nothing, because she was likable. but without putting a specific number on it.
Brendan, in your case, what medical evidence did you put up and how did you put it in?
Yeah, so we just went with two narratives. We had a narrative from an orthopedic who, in talking to the jury, this orthopedic doctor was board certified, went to UNC Chapel Hill, went to UVA. So in talking to the foreperson afterward, he's like, hey, we got this doctor who went to all these great schools. She's board certified. Like, that really carried weight. And then we had a medical narrative from a chiropractor, which I think makes sense for, cases like that. 20, we had about 19K and change, so close to 20 in specials. That just makes sense to me to read a medical narrative, especially because our client didn't have any procedures. I think when you start talking about injections and procedures, you need a doctor on live testimony or video testimony to talk about that. If you don't have that, I think that a narrative gets you just as far is kind of your best way to present the case quickly, because with those, with these cases that are, some might consider these smaller cases, I think you want to get the jury in and out. You want to be as efficient as you can, so they're not sitting around thinking, why are we here? This is ridiculous,
What, how did you read them in? Did you stand up? I've seen it done two ways. I've seen the lawyer stand up and say, I'm now reading the medical narrative of Joe Schmo. I've also seen the more dramatic way. I think Matt Weatherington did this once that I saw it, that either he or had a friend or something come in with a white lab coat on and take the jury stand and read it. I've also seen that done with depositions where you have like a friend come in and pretend to be, they don't lie and say, you say, this is someone that's going to help us read the deposition sitting in the witness stand. How'd you do it?
So I do everything on iPad, and I either bring in an Apple TV and hook it to the court TV, or like Gwinnett, I know Gwinnett has all Apple TV. So I'll put the narrative up on the screen, and then I'll stand in front of the jury. So I'm right next to them.
I didn't know you could put it on a screen.
I put it on a screen. I put up the narrative so they can read along and see it. And a lot of times in the narratives, I have pictures of like, here's the shoulder, here's where the supraspinatus, tendon is. And I have, this is point. So then I'm reading it to the jury, and I'm kind of pausing and looking at them like, plaintiff had a herniation in her lower back.
You get it? Yeah.
Okay.
Yeah.
So then I'm kind of like giving it emphasis there. But I'm also talking to the jury as I read it. And then I remind them, if it depends on whether or not the defense attorney is going to object. But when I get up there, I say, this is the medical narrative. We're allowed to read these. It's testimony from a doctor, and it's to be considered as if the doctor's live. Georgia courts, Georgia law allows doctors to testify via narrative because they recognize doctors should be treating patients. They should not be in court. Their time is better spent. Sometimes they object and say, just read the narrative. Because sometimes you get someone who just lets me, I'm just, hey, this is
I did an intro for a Dr. Depo like that on video. And one time a judge cut me off and said, Mr. Rafi, I see what you're doing. Let me do that though. And I was like, oh, absolutely. Sure. Have you ever had someone object to putting the words on the screen?
Yes. Last trial we did, but we have a bench brief that says, it basically goes to demonstrative exhibits and using narratives as demonstrative. So we just whip that out. Hey, judge, here's our bench brief on this. And they typically don't have anything briefed on it. They're just like, I object because this. And no, well, I can show it. And unless you have some case law to dispute it, it's going on the board, Yeah,
I didn't know that. I don't think I've used one or two narratives at trial, but I did not know. Frankly, I never thought to put pictures in it. I think that's a really, really good idea.
I think
that makes it more of a demonstrative too.
Yeah, it makes it, and with, this from social media, everyone's attention span now is like, it's TikTok, so you have to be as much as you can, you have to be as techie as possible to keep people engaged. You talk about these, I fear that so much, those doctors' depositions where you're sitting there and you see the jurors sleeping. You have to interject some kind of like liveliness so that they're engaged and they think like, this is important. I need to pay attention.
Well, I think part of the way to do that, and it's more fucking expensive, is to set up two cameras. And even if you've done one camera, again, no self-promotion here. If you see the TikToks I do, I just talk and then we cut them down, and we do that by cutting it. And there's some videos, there's a lot of cuts. I wonder about cutting a doctor deposition like that, where you cut, zoom ins, zoom outs, and you just at least try to every 10, 15 seconds, or depending on the answer, every minute or two, just zoom or unzoom to at least give the jury a different perspective. I've done this a couple times in larger cases that I swore we're going to try. I was like, these are going to try, and they're going to be amazing. But as Jim Butler says, you never get to try your best cases. But on these, for a couple, I did depositions where we had 2 cameras, one on me, one on the witness, or 2 on the witness at any given time. And we edited them like it was fucking 60 minutes. Like I'm Barbara Walters, and when I ask a cool question, it was showing me. And that really worked, because that people will watch a 60 minutes interview at least for 8 to 12 minutes. But so we've tried that, but I don't know if there is a solution. You go out to a state like Colorado though, and doctors come live. I mean, that's just doctors come live. We're just in this world where they don't, and it makes no financial sense. That's the problem.
Right.
Colin, what did you do for medical testimony?
So I'm not sure how clear I was on this earlier, but the part of
the doctors, right?
Part of the problem with the case, not a problem, but an issue we had to deal with was that she gets this initial treatment. We get the diagnosis. She has this large gap mostly due to her blood pressure. She finally gets back in with some docs, and this is all before the case gets to my office, but it starts with a whole new set of doctors, and then it's a referral for a second opinion regarding the surgery. And so the course of treatment was convoluted, and there was a lot of doctors involved. We deposed the surgeon who did the surgery, who provided us, did a good job explaining the procedure, also provided some pretty strong causation testimony. The other doctors deposed they deposed the radiologist who read the initial MRI film, who did not read a tear onto the film. And then they deposed the second orthopedic who made the referral for the second opinion, because he did not think surgery was indicated, but he provided causation testimony saying, yeah, there's an injury to this shoulder that looks like it's related to this car accident. So that witness to me he was fine. He sort of cut both ways. We actually only played our guy in our case. They played, and that was a bit of a strategic decision. We could have played the second ortho, because like I said, I think his testimony cut both ways. I don't think it really mattered when it was played. But in an attempt to get through our case as efficiently as possible, not put the jury to sleep, I let them play that deposition in their case.
Did any of the jurors have say to you like, hey, why did they play your client's doctor? Or did they even really understand that?
I don't think that they understood that. I addressed it. Sorry, I addressed it in my opening that there'll be doctors' depositions played in both parties' cases, and that it doesn't matter when they're played. What matters is what they say. So I sort of addressed it that way. But the strategic decision was to get through our case as efficiently as possible and let them bore the jury, which did happen, but it ended up, I suppose, hard to say how much that mattered. But that's what we did for our medical testimony.
That's a good line. It doesn't matter whose case it is, and all that matters is what's said. I like that. We've got a case hopefully coming up at some point where we're considering playing one of the defendant's experts, one of their hired experts, because he gives us causation, and we're debating what we're going to do about that. And he also can introduce some bad facts that we can't otherwise introduce, and we almost want to get him out. So that's something, maybe I'll talk to you about that. That's a really good thought. Were you worried at all about the defense not putting in evidence? Because I'm assuming, Brendan, in your case, I'm assuming you lost final close, right?
No, but in our case, they put in the lien, the letter of protection. So that's
what they lost final close over?
The judge let that in, and they also put in, I want to say they entered her deposition transcript because they wanted to show they tried to impeach her, but it really wasn't like anything impactful. It was like minutia. Yeah, that's what they put in. So they wanted to put, and at that point we had gone back and forth on the lien so much, and she had already said, that they walked together down to the Chiro's office. So we were like, well, let them put in the lien. I mean, that, if you want to do that, then we're gonna stomp you on that.
Did they ever articulate to you what the reason was they were putting 15 on it the entire case?
No, and that's what pissed me off so much. That's because I'm sitting here thinking, We're at mediation. We're here in good faith. I'm sending offers of judgment, which now we have a motion pending for like 100 grand in fees, you know, for the last 3 years. So it's like, you know, don't look a gift horse in the mouth. I go back to that. I know in my heart, right, when I'm trying to resolve these cases, I'm really, really trying to make offers that are fair and reasonable. And when you don't give me any reason for the 15, like it wasn't like she had a prior history of accidents, or I had a young client, 30 years old, no prior history, no anything. They just thought, oh, we're just going to go in there and, you know, see what the jury thinks. I honestly don't know. There was not a lot of communication back and forth as to them justifying these numbers.
Yeah, I've got one. I think it's starting a week from Monday. My client's got 90 in medical bills. Thought was going to have a more invasive shoulder procedure, but they went in arthroscopically and said, oh, it's not what we think it is, but we can clean this out and you know, and treat the shoulder. And there's never been a reason given why there's not more money on the table. And there's no billing expert. There is an orthopedic surgeon, but he agrees my client was hurt. He just disagrees with the treatment. And I'm like, bro, you didn't go in the shoulder. Like, that's what I'm gonna tell the jury. You didn't have a camera in my client's shoulder. You're looking at 5 black and white photos while my client's surgeon was in his shoulder. Like, how can you possibly be more credible? You can't.
Yeah.
Did they float the idea of like a billing expert or of?
No, zero. No.
Crazy.
It's a progressive case. And what I've gotten through this is that progressive does not like me. And because it's like the way that I treat them. And if you're listening to this from progressive, I don't like you. And if you continue trying these cases, we're going to take you to trial and overwork you. So keep offering bullshit numbers, because I love it. It's literally what makes my career. So I take pride in that. I like the hey, you know, this case is worth shit and we're not going to offer you anything reasonable. Okay, let's go, you know? So, because I got more time. I'll put in more time. I don't have any kids yet, you know? I don't have any, you know, I don't have other things that are taking up my resource. I'm totally dedicated.
And your golf swing does not coincide.
Get a little golf in.
I'm just saying it doesn't coincide with the amount of time you spend. So, I mean, you know, from the outside, it looks like you're not much of a golfer. I've seen the swing, you know, it's a little janky in the back. All right. So, so one question I have for you, Brendan, though, is they make these arguments about that really it sounds like it's the attorney making the argument and just saying, here's what I think.
Yeah.
What was your reaction to that as the attorney's just saying, you know, oh, I think there's bias, or I think that this is, how did you deal with that? And what would you do differently if it happens again?
What would I do differently if it happens again? I don't think, I think on the front side, I didn't know that she was going to make the argument of, you know, of they walk together down to the chiropractor's office. So it's now
like she must be a Liverpool fan. You know, you'll never walk alone to the chiropractor.
We beefed up our, you know, our motion in limine on the Stevens case and on how these things get in. So it's like, you know, unless you're going to depose someone in the doctor's office or depose the doctor, you know, because the Stevens case says Dr. Chapius is like a financial investor of sorts in these lawsuits, but they got his testimony in for bias. So the Court of Appeals said they could have gotten it in through his cross-examination. Right. So I didn't know that. What I do with these arguments that they make is while they're in opening or closing and the defense attorney is saying all this nonsense, I'm writing it into my closing, and I'll show you what the closing looks like real quick. And cool. And I'll go back in the closing and say, remember when she said this? Anybody can file a lawsuit. It's bullshit. They can say anything they want. It doesn't matter. She never went to her primary care. She never went to the ER. And you know, the accident that was so severe and heavy, it was just a paintbrush. It was just a transfer of paint, right? So I kind of like to take their words, put it up on the blackboard for the jury and be like, without saying it's bullshit, just like, you can see how ridiculous this is.
Now, did you take it all the way to, look, folks, they are saying that my client is lying or faking or exaggerating and that the doctors are in on this? Like, did you go all the way? Because I've done that in a case where, you know, if you haven't read the book Polarizing the Case, that's the whole idea.
Yes.
did it once all the way. It's scary as shit. You're sitting there and you're like, so jury, if they're calling my client a liar, if you think they're a liar, then don't award them anything.
Yeah.
But if they're not a liar, you got to
I
award them a ton.
Yeah, I've read that. I do that. I don't take it as far as he does. I like more of like the kind of the Nick Rowley approach, if you will, of like trying to humanize it and kind of feel it in your bones kind of thing. You know, this is my client. She's a huge, like, she deserves justice, you know, full. But I do say, if you want to believe, you know, if you want to believe the defendant, you then must also believe I'm a liar, Morgan's a liar. Everyone in my office is just full of, you know, full of it. My client is, the doctors are all in on it too, right? So
we've done it with a board. We've done it with a board, with a line down the board, and people that must be lying for the defense to win. And we've taken pictures from, usually from depositions, of all the people and just stick them up there and stick them up there and stick them up there. And you end up having, typically, you have your client, like you said, the lawyers, doctors, and I'm going to ask about friends and family next, as my dog is upside down. And then on the other side of the board, we have usually the defense expert. That's it. Just the defense paid expert. Colin, I'll ask you first. Did you have any pain and suffering witnesses, before and after witnesses?
I did not. And like I said, that was the biggest weakness of our case. Was, to my client's credit, she was tough, but she just did not. There was really not anything super tangible for us to latch onto this huge pain and suffering argument for. You know, like I said, she missed some work and she couldn't do her normal exercises for a bit, but she got the surgery, she got better, and she was fine. And maybe we didn't do a good enough job of working that up, but really getting into prepping for the trial, that's where I was running into, going, I don't know what I'm going to do. What we ended up going with was, she was a grandmother, and her grandson had some cute name that he called her. So we worked that in, and at the time after the accident, he had been 6 or 7 and couldn't couldn't play in the yard with him or throw the ball or what. There was some stuff there, just nothing super gripping or moving. So there wasn't really.
Why no friends or family? Couldn't find any, didn't have any. What was the story there?
The only thing that the daughter, the mother of the grandson, we considered, but we got some pushback. And to be honest, we talked to her, and just, there wasn't going to be a ton there that I thought moved the jury. And I made a strategic decision to stay with more efficient over maybe some middling testimony.
It's a tough call.
Hindsight's 2020. Would I do it differently now? Especially, again, I don't think that the jury literally awarded zero pain and suffering. They came to a negotiated agreement in the jury room that happened to be the amount of specials. But would I have done it differently this time around? Seeing that, probably. That's why we. So
you'd end up with the exact amount of medical bills under general damages this time, as opposed to the other way. Brendan, what about you? Did you have any pain and suffering or damages witnesses?
We had three people. We had her mom and 2 of her friends come in, and it was just 10 minutes of testimony. Tell us about before and after. It was hard for us because her damages were, there wasn't any, serious, I think her biggest finding was she had some micro tears on her shoulder, and she was recommended injections, but didn't get them. So it was, it was basically like 6 months essentially of going to treatment and how that affected her and, her performances and stuff like that. I think that the best thing is coworkers or somebody that's biased. Everybody believes, that your family is going to help you out. But I think that in talking to juries, right? My case was in Fulton County. I think in talking to jurors, they want even if it is a family member, bring them in, because they want somebody to say, well, I had one 2 weeks ago where there was 3 people in a car, in a truck. My client didn't have the other 2 people that were in the truck come testify, even though it was clear liability, admitted fault. It was a plaintiff's verdict. It wasn't a great plaintiff's verdict, but the jury afterwards said they wanted to hear from the people in that truck. Who else was in there? To me, it doesn't make any sense. Why do you want to hear from, it's admitted fault? We know what the wreck is, whatever. But I think the more the merrier with those pain and suffering witnesses or just regular lay witnesses, because the jury then sees, oh, this is a big deal. All these people are coming into court to testify.
There's 2 cases that still stick in my mind that I've tried that one I lost. asked for $6 million and got a big zero. I would take 100 of those cases though tomorrow, because I'll probably win 10 or 15% of them, and we knew that. But that's one that I, I'm going to be sad for an hour today later on thinking about that. The other one though was in Fulton County, and my clients were hit by a truck that I'm pretty sure was a drunk driver on like a Saturday or Sunday morning, picking up his car from Howells or somewhere over there on Roswell Road, and jumps the curb and hits our clients who are just standing there walking their dogs. There were no medical bills. So the only thing I literally had was that there were two kids, and the two parents were that the two kids were really, really scared, and should have been. The bed of the pickup truck kind of swung and hit them. And that dad was hit so hard he was knocked out of his shoes. Nobody ever asked me what kind of shoes. They were slides, but nobody ever asked me. So I just ran with that for literally 2 years until a trial. And I had sitting in the hallway outside the courtroom, 3 people. I always want a coworker, I always want a family member, and then I want somebody else. If you go to a church, if you go to a basketball league, whatever you do, that's what I try to do. I will say to you, Brendan, I think the best witness is an ex-husband or an ex-wife. I've had that happen once, and that was a great witness. They were like, I was like, do you like this person? His name was Christian. Do you like Christian? No, I hate him. Oh, okay. Tell me about him. And then she goes, he's says like, oh, we got divorced as all these reasons why. And then I'm like, all right, now you don't get any money from this lawsuit, do you? No, my divorce is over. I'm out of here, blah, blah. Okay, tell me now about his injury. But in that Fulton County case, I decided based on kind of James's theory, or sorry, Colin, I'm thinking of how, based on Colin's theory, we did not call those people to streamline the case, to make it fast. Because I thought 3 more witnesses, it was a hit and run case. Why do I need to do this? Number one thing all the jurors said to me was, we really wish we would have had somebody else outside the family come and talk about the injuries and how it's affected the kids and how it's affected the parents. And I was like, I had those people outside, and I kicked myself for that. We still got like $300,000 with no medical bills, because it was that traumatic. But I wish I would have done that. Let me ask you guys now, Colin, let me start with you. What did you ask for, and how did you come up with the number?
We ended up asking for between 350 and 500. And I did not provide, I didn't do the math. I didn't do whatever pain and suffering per day. I always sort of run the numbers on that on the case, and sometimes it works out nicely and sometimes it doesn't. I because of what we've talked about regarding the pain and suffering, I didn't want to get super aggressive and turn the jury off. I just asked for a number, gave them a little bit of a range to work with, basically, 2 to 3 times the medical bills. And defense counsel after says, I thought you were going to ask for 5. So it's everyone seemed to have the same sort of feel on it. I think I stand by the decision. I don't think it would have made a difference what I would have asked at the end of the day, having spoken to the jury and sort of knowing what their reasoning was. But
what was their reaction when you said the number? Did you sense anything from them?
No, I don't think anyone was turned off by it. I don't think anyone was surprised by it. I typically, at the end of my opening statement, preface the jury by telling them I'm going to ask them for a large sum of money for my client. So whatever that means, leave it open to each juror's interpretation. But when they already know that you've got, $150,000 in medical bills, they can, I hope they're at least logical enough to sort of jump from there. I'll say, I know this wasn't your question, but one thing I think is important to talk about in this trial, because I have never had this experience before, was they had Torrance Welch, the biomechanical expert, as a witness, and he didn't have the download. He didn't have any data. He just extrapolated his opinions based on the property damage and the testimony of the plaintiff and defendant, right? So it was completely garbage. And Billy Joyner in my office took the evidentiary deposition on our side, did the cross when they took his deposition, did a good job of, pointing those things out, and along with all the regular, bias stuff. And I spent a significant amount of time in my close just picking his testimony apart, exactly like you guys were talking about. Like, here's all the things that he said that there's just, if you think about it, there's no way that he knows any of this, because he doesn't actually have any math with it. And I thought that was the strongest part of our case, that they're just going to eat that up. Well, in talking to the jurors, more than one of them said, you spent so much time talking about his testimony in closing, we figured it had to have been credible or damaging to you, which was, I've never heard that before from a juror regarding, picking apart an opposing party's witness. So I thought it was worth mentioning. I was shocked by that.
Yeah.
Maybe I didn't make it simple enough that all they heard was me talking about it, so they must be credible. But I did think that was worth mentioning because it was an experience that I had never had before in talking to a jury.
Man, yeah. I can't believe jurors even thought that. That seems like a lawyer thing to think about. If I spend too much time, I've never heard a jury articulate something in that way. I asked you if what the juror's reaction was, because that case I'm going to be sad about for like the next hour, where I asked for 6 and got 0. I told the jury multiple times that I thought it was a multi-million-dollar case. When I said to them 6 million, I thought I had it in closing. I really did, but they're all writing. And when I say you should award $6 million in pain and suffering, I watched all of them go, put their pen and paper down, look at each other. No, look at each other. Look the other way, shake their head. This is like, to me, this took 4 minutes to happen. It probably took like 4 seconds, but and then look down. And at that moment, looking back, right? At that moment, I wish I would have said, whoa, you guys clearly don't like that number. Let me try again. Or because, now knowing I would have done anything. I would have done backflips if I needed to. But that's the scary thing, I think, is when you say the number, and you don't know what the reaction is. You almost have to be prepared to, for it to be cool based on what the reaction is. Brendan, what did you ask for? And then what was your verdict? I don't know if you said it.
So the verdict was $55,885. I'll tell you how they got to that number because it was very weird. But I'll show you what I do. This is just a screenshot from I basically take the scales of justice. We go through preponderance, and I say, here's all this testimony. Here's all the evidence we've shown. And for this case, the defense didn't put on any evidence. So here's this question mark, right? Like, what the fuck are you going to think about? They didn't do anything, right? Here's the mountain of evidence. So it's not just preponderance, right? We've literally carried the day with all the things we presented, right?
Do you play the Rocky song as this is happening? Dun, 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 dun. I mean, like, that was more The Price is Right there. I don't have good rhythm or beat, but I guess the Price is Right music would work too.
For this case, I gave him 2 options that I wouldn't do next time. Is option 1, I said, this is how you enlighten your conscience, multiple of the specials. And I gave him the numbers for the specials. Option 2.
This, by the way, wait, go back to that slide. Go back to that slide. The brain, I'm going to give you some thoughts. The brain, to me, the enlighten your mind, this looks like a cult. This looks like this is a slideshow to donating to Scientology.
Hey, you got to keep them interested. You got to keep them interested. Right? You got to have.
Did they think they were joining a cult here, and that you were going to like put them up in a commune?
That's the conscience being enlightened. All right.
No, I get it. I get it. I just
the second. I try to keep visuals. I try to keep them engaged. Somehow, right?
I think that even someone acting like I am, like kind of poking fun at you, I think that's a good enough reaction to have. Somebody's going to remember the slide. I mean, truthfully.
That's what I want. The second thing is I literally go on Indeed and I make a post as to here's what the job would look like. And I actually did this in the last trial.
I haven't seen someone actually put it on Indeed. This is awesome.
This is the funny thing. I had people apply to the job and call my office and I'm in trial. Man. I'm in trial getting messages like, is this for real? And I'm like, oh my God, no, sorry. But you have to.
This is awesome. This is awesome.
So I make it look like, look, you're scrolling Indeed. Here's all the things that the job requires. You got to, my client testified she had to gain 25 pounds. She couldn't go to yoga. Part of her thing was, and part of the theme was in her testimony, she said personal health is a pillar of her life. So in jury selection, we said, how many people would consider health a pillar of their life? And we went back to that in closing, right? So I give them the job test and then I say, $10 to $20 an hour. What the jury said in when I talked to them is it felt like I gave them.
Did you just scroll off there because you asked for $1 million?
No, here's what I did. I'll show you. But the hourly thing is, if you do $10 to $20 an hour times 16 hours a day, right? You sleep for 8 hours a day, right? So 16 hours waking is between 160 and 320 a day. If you do $20 to $40 an hour, which she testified, the plaintiff testified that her hourly rate when at her job was like 45 an hour or something. So that was 320 to 640 a day. So I said, you multiply that
by the number of days.
By the days. So if you do for 60 days, that's how much 10 to 20 is. or 20 to 40 is. So the jury said afterwards, the foreperson said this kind of felt like it was choose your adventure. That were his words. Now, mind you, this guy was an Army vet who, by his own admission, said, I've been blown up multiple times in the Middle East. I've got all these plates in me, blah, blah, blah. So to him, I think he thought this is just a little bit of pain and suffering. Like, it pales in comparison to the shit I had to deal with and still have to deal with. Right. Which,
he actually found that job post and he applied to it during the trial, probably because he's like, this is, I've been through this before.
But then I go back and I go through the jury charge and I say, here's how you can distribute this damages. And David Ball says, put up a pie chart, and show them a pie chart. So I say, you do the specials, you do the generals. The hardest part for me is showing them. And so I said minimum verdict 219. The jury got to 55 by saying, okay, what's her hourly rate? They basically gave her like 3 days a week where she was suffering because she had to go to appointments and stuff. And they didn't do 16 hours a day. They did like 8 hours a day. So they basically came up with their own with their own calculation. And that's how they got to 55. Did we put the number out during voir dire? Yes. In voir dire, I ask everyone, does anybody have let me show you what I do. I say, does anybody have a problem awarding a verdict above $200,000? And if no one raised, we note that. And if they say yes, we take them off the jury. I'll show you what the screen. So I go back to that slide and I say, remember when I asked you, does anybody have a problem awarding over 200K? No one said.
Fun fact, you can't do that. I found that out the hard way. Just being the appellate counsel during this this webinar. So you can't refer to anything that happened during jury selection or before opening statement. Just fun fact. I didn't know that. I did it and found that out on an appeal, which thankfully went my way because they didn't object contemporaneously at the time. Because I looked at a juror and I was like, we got our money guy here. We got our financial planner. He's going to tell you. You're not allowed to actually bring up anything you learned during jury selection. Fun fact.
I didn't know that.
But keep doing it. Keep doing it until somebody objects. I mean, shit.
There was no objection, but I basically try to keep them accountable by saying, we talked about this. You knew this was going to happen. I think the hardest part for anything is pain and suffering. How do you give them a number? How do you give them a calculation, a quotient to figure out? Because they're looking for tools that they can go back, and you want to arm them with, hey, look, when you're back there, here's what you should be thinking about. You need to take, some responsibility and accountability to figure this out. And we trust you to do it. But I think that we talk about it all the time as lawyers. We get it. But to them, I think that I still have not found a way to make it stupid simple of here's how you do it. Here's what's reasonable, go back and figure it out.
Look, here's how we sit in my office and figure out how much cases are worth. Let's say a guy comes in with a broken arm. It's his right arm. He's a righty. And it gets repaired and he's okay. Let's say he's totally recovered 8 months later, start to finish. I sit around and I open up a beer and I say to everybody in my office, hey, how much for me to break your arm? You'll be ready. You'll be back in 8 months. The problem is we can't just say that to the jury. You can't explicitly ask them to put themselves in the position of the injured person, which is what should fucking happen. I mean, that is the whole idea. And until we can do that, we have to keep coming up with creative, multiple options to do that. You said you wouldn't do, Brendan, would you give both of those options to a jury again, or do you think you'll go to one or the other?
No, so that I had a case 2 weeks later where I just did the straight job description. Because I think with some of these smaller property damage, smaller damages cases, the job description makes sense, but I still am not convinced that it's the best one, but I'm looking for some kind of formula where we can determine a daily amount. Colin
went the other way. Colin said, from what I gather, said, here's my feeling. Here's what I call that I refer to it as a feel ask. And I say to the jury when I do it, look, I always say there's no right or wrong way to do this. But I'm going to give you a couple ideas. Magically, they all come out to be about the same amount of money. But the one I typically either start or end with is, look, at some point, you got to look in your heart of hearts and say, what makes me feel like I'm doing right by this person? And in my heart of hearts, the number is this. And that's just what I feel. And I can't tell you why I feel that way. You might feel differently. you might think I'm stupid high, stupid low, but that's what I feel. How did you present the number, that the range you gave, Colin?
I think you're right. You have to start with saying there's no right answer to this question. Whatever. I've been doing this for how many years, and no one's ever told me the right way to come up with it. I think that the theory behind doing it is, without providing a formula or some sort of detailed explanation as how you got there, is if you have done a good enough job of convincing the jury of your authority on the matter or on law or personal injury or the trial, then you are banking on them trusting you as to be their guide as to what is a reasonable thing to do in this situation.
Yeah.
Obviously it doesn't always work, but I think that's at least the theory behind it, is that you've done a good enough job presenting your case and being reasonable and prepared and knowledgeable that you can go with that. I default to that when I can't make the numbers work. Sometimes, like I said, depending on the length of pain and suffering, the amount of the specials, whatever the person different, sometimes the numbers just work. And I prefer to provide a method or a formula if it makes sense to me. And in this specific case, I couldn't really make it work in a way that made sense. So we just sort of went with, this is what I think. Y'all can think differently, but this would be a reasonable thing to do, essentially.
Yeah. And Patrick just kind of put that thought in the comments, is if the jurors believe you, why give them multiple options? If they trust you, just give them the one. My response to that is I'm with you. I mean, my preference is standing up and saying, this is what I feel. Y'all trust me. I trust you. Give the number. But at the same time, depending on who's on your jury, we've had people who I can tell are more numbers people, your financial planner people on one hand, or even your hourly employees on another. So I think that I like to give two. I've even given 3 options before, but I like to give 2 options that magically come out to be about the same. I think giving 2 that come out to be in the same range, or even 3, gives you credibility, because you're saying, here are the 3 ways to do it, and they're all going to come out be the same. What I get worried about sometimes is, a defendant coming out and saying, well, yeah, he told you about 2 ways, but here's the 3rd way, and the one that you should actually use, and it's, a quarter of what I'm asking for. But I think it's a feel thing, and I think you can't really make that decision until you have a jury sat and you know who they are, because, I always come into every trial with 3 calculations. I do the wanted poster, although I've never done it on Indeed. I want to steal that shit because that is awesome. But I do a wanted ad. Mine is more of the old school wanted poster. That's what I think of. But a wanted ad, I do a field number, and then I do some sort of calculation. Brendan, you said you want it on a daily basis. Sometimes I break it down to hourly. Sometimes I'll break it down, to whatever. And even within that numbers calculation, sometimes I'll do a range of, here it is at minimum wage. Here it is at $15 an hour. Here it is at $40 an hour, or something like that. But if those numbers all kind of come up to the same, I think it gives you some credibility, and it goes with your idea of telling the jury, I don't know how to do this. Nobody knows how to do this. The line I say is, I'm jealous of you that you all get to make a decision about who wins or loses. But frankly, I'm not jealous of you about having to pick how much money, because that's a really, really impossible thing to do, and something that all the lawyers here have been struggling with for 3 years. And that's why we're here.
I think what happens, and what happened with that jury specifically, because we talked to a lot of them, is we give them these calculations, and then we go back, and some of them say, sure, let's go with it. And some of them say, hey, let's go with this one. And so eventually they all get down to like, okay, let's take a vote. Who wants to go with this one? Who wants to go with hourly? And then they end up coming up with their own, smorgasbord of a calculation. And so it's like,
I like to start with some premise. Like in a death case, this is an easy example. I say it and I use it because it's an easy example. But every year of your life is worth at least $1 million.
Yeah.
And no one can disagree with that. I don't think, and what I do, my favorite thing is I look at the defense lawyers, and no matter who the fuck they are, I turn and go, there are people in this room that make $1 million a year. and I just look at them, and everybody knows what I'm doing, right? And I say, there's people in this room making $1 million a year, and they're going to, and somebody's going to come up here and tell you that a life isn't worth $1 million a year. I think if you can find a person's day, no matter what, is worth 20 times, $20 times 24, or whatever, however, 20 times 16, if you're carving out, I wonder if you can start with like a premise of, this is something we all should agree is true. And that's almost your floor. Right? That's almost your floor. I don't know. I don't have the answers. I wish I did. For anybody interested, there are 2 or 3 other webinars on on that I have on this subject. One I did at GTLA 2 years ago, I think, called The Ask, which is on our YouTube page. I'll send it out when I send this email. If anybody wants a thought, I went through the wanted ad, spent a good amount of time. All right, guys, last thing I'll ask each of you. What's one thing that you thought you did extremely well in this case and that you'll keep doing? Because everybody talks about, oh, I didn't do this and I would do this differently. What's the one thing that you did and you said, shit, this is good. I'm going to keep doing this and I really liked it?
Ooh.
Because we all talk about changing, right? I'm filling the air to give you all more time. But most of these webinars, the thought is, what are you going to change and what are you going to do different? I just want to know, what's the thing? Maybe it's your bread and butter. Maybe it's something that you did for the first time, but you said, you know what? I like this. I'm going to keep doing it.
Yeah, I think with me, it's finding ways to be creative with the case specific. I'll give you an example. This is something that I felt I've never done this before. And I talked to my, the wife test is always good, or the spouse test, right? Run it off of somebody who is not a lawyer. And I did it with my client. So my client in this case she's a singer. She's on Spotify, iHeartRadio, does shows, right? The testimony was, she missed out on shows. And when I say performances and shows, I mean, like, goes down to a local bar and, we'll have an audience of 40 or 50 and performs and sings, and it's beautiful. So in this case, the jury ended up saying they were split on this. All the women loved this. The white men, not so much. But
what was the race of your client?
Well, my client was an African-American female.
Okay.
And going back to Fulton County,
is this a Rihanna Super Bowl halftime show? Like, is this what we're preparing for?
You're about to see. So I put, I asked for the verdict. I asked for the verdict, and then I put up this slide and I say, if I was up here representing Beyonce or Taylor Swift, right, and I was asking for $200,000, you wouldn't blink an eye, right? Because they make $1 million a show. And but what is the difference in the value of life between Beyonce and Miss Parker? Everyone is equal under the eyes of the law, right? It doesn't matter if it's Beyonce. It doesn't matter if it's Ashley Parker. Everyone's equal. And, I felt like I was going out on a limb with that one because it just seems so. But at the same time, I think that for that case, because my client's a performer, because she does, similar acts and performances, I thought it stuck. And in retrospect, all the women jurors said, we love that. And that really hit it home, and it made it seem like it was equal. The military guy who was the foreperson was like, but fuck, who cares?
What do you think? What do you think if you would have put men on the slide? If you would have put like a Matt Ryan, I don't know, pick your poison, Dansby Swanson, the white women love that.
That's a good idea.
Wonder if that would happen.
To put something like that. I mean, the reason I got this idea is because there's that argument of hey, I'm asking for millions of dollars, and Chipper Jones just signed a deal for 30 mil for blah blah blah. You know what I mean? So that's kind of where it came from. I think at the end of the day, though, jurors right now are stressed and split, and it's really hard to get communal agreement on what they all think. I mean, I think the jury process is still the best process we could have and ask for, but I think it's hard, especially in Fulton County, where it is very, like, it's very diverse. You have people on your jury who are millionaires, and then you have people on your jury who are struggling just to get to the MARTA station to get to trial. So it's like having all those people come together and agree on something is difficult, but we got to keep finding ways to kind of help bring them all together so they can make a decision for us.
I got something here real quick, I think. Let me see if I can do this. I don't know if you guys can hear music. Can you hear sound right now or no?
Yeah.
I was playing some Rihanna. I think you should put that in the background next jury trial that you have. Bitch better have my money. You're going to get a wider range of thoughts on that. And I'd love you to come back and tell us what the reaction is when you're singing bitch better get my money in the courtroom. All right, Colin, what do you got? What's the one thing you keep doing?
I deferred the first close for the first time ever. I'd always taken first and last close, or obviously if they didn't put up any evidence and they stole last close, and you're going first. But I deferred my first close and just took last close. I think that's a strategic decision based on the amount of evidence that you have to cover in a closing, maybe. But I loved the fact that I could get up there and I could use analogies and make arguments without fear of defense counsel coming up with something clever to turn those arguments on their head, while maintaining the ability to still do that to defense counsel without any fear of, them making a counter argument or having the ability to do so. I think it's a case by case basis, but I liked doing it, and I will do it again in the future for sure.
Interesting. What gave you the idea to do it in the first place? Try this one. What gave you the idea in the first place to do it?
Billy Joyner, who I had mentioned in our office, did it in a pretty small case a couple months ago, and we were just talking about it. And he's for the reasons I sort of said. He said I liked it. Like, there's not too much to cover, so it doesn't get monotonous with you just droning on trying to cover all the evidence and make all your arguments and everything. So consolidate it, have the last strong word. Don't let defense counsel get a chance to argue against anything you said in your first portion, and just sort of end strong. So I will do it again. I thought that was effective.
It's a good idea. That's a good idea in the scenario. I don't know.
Your offer of settlement, Colin? Did you get your offer of settlement on this case?
No.
Okay. I heard you say earlier about they filed an offer of settlement for 4. I think defense counsel they're really stupid when they file these offers of judgment not related to specials, because all the case law suggests that they can't use these offers to bar you from the courthouse. They can't just make some bullshit $4,000 offer on 130 in bills and say, oh, now I'm going to collect on this if I get a defense verdict.
I got one for you. Imagine you have $400,000 in medical bills. There's a blown demand pre-suit, and then they send $100,000, which are the policy limits. They send $100,000 offer of settlement, which has nothing to do with the case. All it has to do with is the insured's policy limits. Right. That's what I'm seeing a lot in bad faith cases, or cases with bad faith potential. When you're working on the underlying claim, they're trying I'm trying a case in June, especially said in Fulton County through that alternative kind of, it's not alternative, but just a senior judge. I think we have 92 in medical bills, and there's $100,000 policy and a blown policy, and the offer of judgment sitting at $100,000 from the defense, because that's nothing to do with based on the bills or the case. It's just we're going to extract leverage. I just don't see the benefit of defendants doing that at such a low number. Thankfully, though, frankly, they don't go and do it at, put the number at the medical bills, because that would make it tougher, or medical bills plus 5,000, because that would make it really tough. It shows that their motives aren't true or pure. They're just, trying to penalize your client for a situation they didn't put themselves in. But that's another topic. I appreciate you guys coming. Thank you. Thanks for Colin. Thanks for getting dressed up. Flanagan, thanks for combing those luscious locks of hair. I appreciate you guys. Will you, before I'm going to kick you off here, but I have to, that's the way it works. But if you will, if you're okay with me, I'm going to send your emails out to everybody so that they have them. And I'll send you on the quick email chain I'll do to everybody that's on here. So that way they have your contact information. You guys can talk shop if you all want to. All right.
That's good. Thanks, Mike. Enjoyed it.
All right. Thank you guys. Everybody, I am almost through as these guys exit to never return. But I just want to say thank you for coming. The two things I'll talk to you about is, if you're getting close to trying a case, there's a lot of resources that are out here, a lot of people that want to help. So please know that whether it's me, whether it's somebody in my office, whether it's somebody down in the hall, or whether it's the two guys I just had on, if you're getting ready to try a case, there's a million people that will help you prepare for it and want to help you and see you succeed. If you're ever going to a trial and looking to pick a jury, and you're saying, God, I got to do all of this myself, don't. Call me, call somebody else. I will sit and pick a jury with you for free every day. And there's a lot of people that make that offer just because it's a lot of fun and I wish I could do it more. So with that, please know that even if you're in a small firm, even if you're a solo practitioner, you have a lot of help and a lot of resources just by the people on this webinar and the questions we've gotten. You have resources, and don't ever go into a case alone, or into a trial alone, and don't ever go there without pitching your idea to a million people, whether it's Brendan talking about the spouse test, or whether it's me talking to a 9-year-old, or whether it's accosting the Uber driver when you have a captive audience, where you say to the Uber driver, instead of, hey, how long you been doing this? How's your day going? Wow, traffic's bad today. You say, hey man, let me ask you about a case I have. This is going to be crazy, but let me tell you. That's my take on maximizing Uber rides. It's probably why I have a couple 1 stars. But anyway, make sure that you use all your resources and know people want to help you and people are here. And I'm always here if you guys need me. Y'all know how to find me. If you haven't been on this webinar, let me tell you this for the first time. If you have, you probably know what I'm going to say. I'm going to shoot an email out to everybody on here with some thoughts, some takeaways. I'll remind you of Brendan's actual LinkedIn post. I'm going to see if he'll give us his slide or his bench brief on displaying, I guess, showing the jury the medical narrative, because that's what I learned today. If that's true, which I assume it is, I mean, I have no reason to doubt him, but I'm going to incorporate that if I ever need a medical narrative, because I thought that was a really good idea. And take with you what Colin said, which is, sometimes the feel number is the right number. You just got to give the feel, and I believe when you give a feel number to the jury, you have to believe that. You have to believe it completely, and you tell the jury, I believe this number. I believe this number. So anyway, I've got a trial, I think, starting a week from Monday. I'm waiting for confirmation here. That trial is in Gwinnett County. Pamela Lee is the defense lawyer. I'll give you all an update on that case, and I'll also send out an email, assuming it's going to go forward, which I believe I'm number 1 on the calendar. So I will, I'll send an email out to everybody and tell you where I am and what's going on. And then I know I have a specialist at trial in June in Fulton County in front of, well, it was in front of Judge Besson. It's been moved to that, I think it's called Orca or something, the Fulton County side project where they're trying to clear their backload. But those are the ones I have coming up. If y'all want to join, I mean, hell, it makes me feel good, and it shows the jury the importance of the case if other lawyers join. So I give you an open invitation, and I'll make sure that all of you know when I'll have trials. I'd love to hear when you guys have yours, and I'd love to come. So thank y'all, everybody. Enjoy Thursday. Have a good weekend, and maybe I'll see some of y'all a week from Monday or so for my trial. And I'm getting told it's called Orca. I was right. All right, cool. It's called Orca. So thanks, guys. If you have any questions now, last minute questions, now's the time to ask them. I'll hang here for a minute as my screen shakes and answer anything you got. But that's the end of the webinar. No grand finale today.